Good afternoon, everyone. We're the Cannabis Legal Group. I'm Nick Galendez.
And Jennifer Domingue.
Welcome to episode 76. We got a lot to talk about, primarily the death of temporary operators. But just wanted to start off by wishing everyone a Happy New Year. I think that we've gone a long way since last year when applications were just getting up and running last December 15th. All the way through now, we have licensed operators up and running. There's still a lot of applications in the pipeline, going through vetting by Laura, getting decisions by the board. So, a lot of exciting things are going to be happening through the next year, 2019. Hemp is federally legal now. It's also legal in Michigan, and we're going to talk about some new developments and changes that have actually been signed by the governor and go into effect, already have or will be soon. And then we're going to kind of go into the big question that everyone's kind of been talking about now with temporary operators and how they are supposed to navigate this and kind of things looking forward from that.
Absolutely. So since we last spoke with you guys, so much has changed already within just the last week or so that it's been crazy. We've had multiple bills be signed into law, and we've had the state shut down all the temporary operators. So we have a lot of really good content for you. Feel free to ask questions. We'll be commenting our answers in the comment box, and we'll be trying to answer them as we go as well. So Nick, do you want to talk a little bit about the industrial hemp progress that we've been making?
Yeah, so a few episodes ago, Travis and I kind of highlighted the new bills that were potentially coming on board with hemp. They have been signed, and I believe they go into effect on the 15th of this month. But basically what they do at the state level is they create a licensing framework for both growers and what the state is calling processors and handlers, which will be able to cultivate and process and market and sell hemp and hemp derivatives, CBD, and a lot of other different products that are going to be coming from the industrial hemp plant. So what basically legalization at the federal level allows is for states to create their own licensing framework, somewhat similar to medical and adult use marijuana, where you can't just freely grow hemp, at least under this, it's kind of a little distinction between the law where in Michigan you can grow up to 12 marijuana plants per residence, but you can't grow any hemp anywhere unless you have a grower registration from the state. So that kind of what the new law actually will create is a $100 application fee, which is renewable annually. You have to apply with personal info. 10% or higher equity owners would need to be vetted. You need to create kind of an application with a map showing your location, and even what I thought was interesting was the GPS coordinates of where you'll actually be growing the hemp. And you can also, what the state's going to allow you to do is kind of create connections between this and at least for now, the medical framework, where if you're a grower and you're growing hemp at a certain location, you can request during the application process to be able to sell that harvested hemp to MMFLA processors. So that's the first kind of part of it. The second is what they call the processor handler license. That application fee is a little bit higher. It's $1,350, and it's renewable annually as well. And you basically, as I mentioned, you can't process, handle, broker, or market hemp unless you're licensed. And so what that kind of means is for handlers, that's possessing, storing, or transporting it at a licensed facility. So if you think of a provisioning center employee kind of handling medical marijuana product, kind of the same thing with hemp, and you need to be a hemp handler in order to kind of be working there. There's a broker, which kind of allows you to negotiate between the buyer and seller, somewhat of a wholesaler. And marketing is defined as promoting or selling a hemp or a commodity or a product. So for all of these different kinds of activities, you're going to need to have some type of registration or a license for. And the application for the processor handler is somewhat similar to the grower, where you need to give personal info about the equity ownership, things like that.
Absolutely. And Laura the department is reserving the right to deny these applications for a couple of different reasons. They are requiring that the applicants be 18 or older, which makes sense. They're also reserving the right to deny somebody if they're not responding to the department in a manner that they think is appropriate. or if they're not willing to comply with the rules and the instructions of law enforcement or with the department. If they have any unpaid fines or any sort of civil penalties to the department then that haven't been paid, then they could be denied renewal of their license. And if there's been obviously any false representations made to the department, then of course they're going to deny that application as well. Overall, these seem like pretty clear-cut reasons for denial, and I think that the application framework is pretty low level. It's not nearly as intensive as the MMFLA, or it doesn't appear to be as intensive. I mean, obviously we haven't seen the actual application rolled out yet, but with this framework, it definitely gives a lot of individuals the opportunity to enter into the Michigan market. That's very exciting.
And just like with the medical framework, rules and the application will have to be rolled out, and so there will be more things fleshed out when that happens. And the law, as Jennifer said, just kind of creates a framework and a skeleton for what the system is going to look like. And so with that, there are some rules that are kind of solidified into the law. Similarly to the MMFLA, hemp licensees will be subject to inspection and collection of samples at any time without notice. Any cannabis plant that has over 0.3 THC will be forfeited. And there's going to be rules, significantly more rules on growing, handling, and storage of it. But what there is in the law is that you can't interplant hemp, meaning just kind of having it within other kind of crops without the permission of the department. You're allowed to transport 2.5 ounces to a testing lab to verify, and microbials and things like that, but also that it's under that 0.3 THC limit, which is actually very important.
Absolutely. So I know that there's a provision in there that has a criminal penalty, and it's pretty severe. It's a felony, right, Nick?
Yeah, so a false sample of hemp, if you misrepresent that or you give them one, a few of them that aren't over 0.3 THC, and then the rest of your crop is well over that, you're actually going to be guilty of a felony. And that's a pretty harsh penalty, but I think they're taking this seriously. They don't want you to apply for a hemp license, grow a bunch of the plant that's over that, and try to kind of pass it off. Right.
So a lot of felony guidelines on the criminal side, generally it's either imprisonment or a hefty fine. Something that I noticed that was pretty significant about this criminal penalty is that the felony is imprisonment for at least a year, for between a year to 2 years, and a fine of $5,000. So there's no like if or that sort of thing. It's both. So this is a pretty serious felony on the books now, and so I think the state is really making strides in trying to crack down on making sure that this is like a heavily regulated industry and people are taking it seriously.
And so that kind of wraps up a few of the basics on the new hemp laws. Once they become actual laws and become effective about a week or so from now, we'll expect the department to continue to release more information and rules and start creating that whole framework for it.
Right.
There were also 2 other bills that kind of were more administrative fixes to the public health code with the definition of industrial hemp. And also, I believe some portions of the MMFLA were tweaked a little bit in order to allow, those growers to interface and for those processors licensed under the MMFLA to bring hemp product in from those sources. Other than that, though, I think, kind of transitioning into the MMFLA, there were also some bills. I know there was a lot of talk about House Bill 6500, Senate Bill 1243 prior to the holidays and the New Year and the change in administration, but we do have some more clarity on what was passed into law, what wasn't, and then, we did get the final authority that the governor did sign those, so we're going to kind of discuss those and then go into temporary operation and discuss all that.
So for some of our regular viewers, you might remember a couple of sessions ago I was talking about how we had a lot of legislation up to amend the MMFLA. We had a Senate Bill 1243, oh my goodness, so many numbers, 1243 that basically gutted the MRTMA, and basically imposed all of these difficult portions of the MMFLA onto the new legalization of Marijuana Act. We also had House Bill 6500 up that really took some of the issues that we were having with the MMFLA and attempted to fix it. The good news is that the Senate bill was rescinded by the sponsoring senator, so that did not pass, and the House bill just didn't go anywhere, unfortunately. But we did see portions of that bill get implemented into Senate Bill 1262. Senate Bill 1262 was passed. I believe that was one of the last bills that were signed into law by Governor Snyder as he was outgoing. And it has a couple of really big impacts on the MMFLA. One of the biggest things is that the definition of applicant has been changed. So the way that the law was drafted before, it was super broad. And it basically said that if you had any indirect or direct interest in this business, that you needed to disclose it, that you needed to provide your bank statements and your taxes and all of these other supplemental documents, and you needed to be vetted. And if your criminal background didn't pass muster, or if your finances didn't pass muster, then the entire applicant could be denied, which is kind of scary when you have people who have 1% ownership interest, or it's a very nominal amount, and they don't really have control, but they're still being vetted as if they have 99% interest or 100% interest of this entity, and that the entire application could fail because of, you know, something that is on somebody who only has like 1% interest. So the way that the state has revised the definition of applicant is much more specific as to who they're looking to vet now, which is really nice. They also completely removed the term true party of interest. So a true party of interest was somebody who was, the state thought would be like tangentially related to the business in any capacity. So if the state thought that you know, you're an owner, you're a spouse, you're related to the business in some sort of formal capacity, then you would also have to be vetted. And that led to a lot of confusion. The department didn't necessarily always apply it the same way across the board. It was very difficult for applicants to figure out who needed to be disclosed and what all needed to be provided. And so there was just a lot of confusion revolving around this term, true party of interest. And so we saw the state just get rid of it. And that's awesome. I'm really excited about that. That'll make the applicants' lives a lot easier. And honestly, it's going to make the state's life, the analysts at the department, their lives a lot easier, because now they don't have to look through all of these documents for some people who might not be as important to the application. We also saw a threshold where people don't have to submit all of their information if they own less than 10%. So that's really nice. And there's also a little tweak for publicly held corporations where you only have to disclose your stockholders if they own more than 5%. That tracks well with the SEC reporting requirements, and it also allows for these publicly traded corporations to enter into the Michigan marketplace. Before, we really didn't have an option for that, because if you have to provide a update to the state, or if you have to provide information for anybody who owns any interest in the applicant entity, you're not going to be able to provide that for a publicly traded corporation. It's impossible. That's traded on the market, and you're not going to be able to get all that information and have it accurate and complete. At least now with these new thresholds, those publicly traded corporations can now enter the Michigan market, and I think that's really awesome.
And I think with all these changes, as Michigan evolves, you see them, anticipating, okay, let's start generally. Let's create an application that's applicable to both if an entity is applying and if an individual is applying, and we'll call anyone else who's associated with that a supplemental applicant, even if it's another company or a corporation, or an LLC, a trust, a person. And I think what they've seen is they're running into different situations where they've, it's kind of a square peg round hole thing, and not a lot of, not every situation fit what people were proposing to apply under. And so, as Jennifer mentioned, with, let's say with a multi-level ownership enterprise, that's just, entity, applicant, LLC, LLC, LLC. The old rules said that any percentage of gross or net profit that was entitled to those entities above the actual applicant license holder had to be vetted and fill out an application and submit 3 years of tax returns and bank statements and criminal history and civil litigation. Now that's kind of been relaxed more to say that only those entities that have the right to receive more than 10%. So you could have some smaller companies up in the umbrella that only get 1% or 9%, that the government has finally decided that those ones aren't necessarily, not to say they aren't important, but that's the kind of, level of scrutiny and the bar that they're setting for who they decide and who they determine needs to be vetted. And so what we're going to keep seeing, I think, is more specificity for different fact situations that don't necessarily fit even this model, as the rules continue to get tweaked and the application process continues to be refined, and they keep, figuring out how they want to address each different situation that comes on board, which will just kind of make it easier for everyone involved, from Laura, the Bureau, the attorneys working on it, even the architects, all of the applicants and their spouses and investors and institutional investors and money lenders and everyone. I think that we all can benefit from more things being fleshed out and having more clarity on everything that's going on. But everything's been a moving target, and it continues to be. And so it takes time for things to settle in and for the industry to actually take shape and get figured out. So
Absolutely.
It's in all of our best interest to work together, have a voice, and to kind of make that all known as to, if there's specific issues that you keep running into, make sure that the regulators know that and continue to work with them towards finding a solution.
Absolutely. There is one other point that I wanted to bring up about this other bill, the Senate bill that I was just referring to, and I think it's really important because it was kind of an oversight in the prior version of the MMFLA, and that's if you have a law, you say, okay, you businesses need to do this. Well, what's the consequence if they don't? What's the consequence if they don't get a license? What's the consequence if they hold themselves out as being a licensed business, but they don't have a valid license? So the prior version of the MMFLA didn't really talk about this. It just said, you need to do this, but there was no consequence. So now the Senate bill imposes a consequence for people who hold themselves out to be licensed entities. And that's basically a misdemeanor. They're generally all misdemeanors. If you have the first offense, it's a misdemeanor, and it's a fine of between $10,000 to $25,000 and imprisonment for up to 93 days. If you have additional violations, then it's probably about the same fines, but the length of jail time or prison goes up. And if you are selling a product and you're holding yourself out to be licensed and it results in death or serious injury, then that's a felony, and that's prison for up to like 4 years. So they're taking this pretty seriously, and that really segues well into the temporary operator thing, because right now the state just shut down a ton of temporary operators, and if they are still conducting business without an active license, then they could be subject to this new criminal charge here. Mm. So Nick, do you want to talk a little bit about temporary operators?
Yes. So I think it's important at this point to kind of claw back a little bit and talk about what a temporary operator is, or at the time that they made this, and then how it evolved and where we're at now. So just to kind of give the little lay of the land right now is that, as Jennifer mentioned, any facility that was temporarily operating with local approval that submitted its application by February 15th, 2018, was pursuing a license. There were certain deadlines for them to shut down, which eventually got postponed by a court order, by the Court of Claims judge. That order recently expired as of December 28th. And Laura said, okay, at the end of the year, December 31st, all unlicensed activity by temporary operators needs to cease. What happened about a year ago was that there was a lot of pushback when Laura first announced that it wanted to shut down temporary operators, and I think the board was on board with that. At that meeting, there was a lot of public outcry. There were a lot of interested parties, patients, caregivers, facility owners. A lot of people voiced their opinions, and it seemed to work. It seemed to make the board change its course a little bit. Laura said, okay, we are going to issue this temporary rule, this emergency rule that allows temporary operators operating with local approval to continue operating. What that meant was that they wouldn't use that against them in granting them a license, because if you're, for patient access, for patient needs, we are going to allow this to happen, which isn't contemplated in the law, which technically is something that still violated the law. But they said we would allow it to happen and not hold it against you solely for that reason. And that still kind of got some pushback from some board members, but it was something that couldn't just be used, otherwise they would have said, oh, this is a temporary operator, I deny them for this reason, boom. There were some other reasons, I think, connected to temporary operation that were used as a basis to potentially try to deny someone, but not just being an operator on its own. But I think it's still important to remember that this was all based on a rule that didn't have really any legs in the law, that was allowed to happen for the sake of patients and to not throw the whole system out of whack. As we've seen, though, is that the licenses have been slow to roll out. And so that's kind of why we saw the new emergency rules get issued and new advisory bulletins get issued that pushed the date back and forth. And it continued to kind of be a compromise between, when are we going to have the cutoff date? We do have licensed facilities up and running. They may not have paid their regulatory assessment fee because the system, I think, is still broken. It's not, maybe not broken, but not fully operational by any means yet. And there needs to be a balance between when do we cut off those who have, been operating with local approval versus ones that are waiting versus ones that are finally up and licensed. And I think finally, at the end of this year, after this court order was lifted and got expired, was when it kind of ended up being that final cutoff date, at least for now.
Absolutely. I think the state's view is, listen, we have to draw a line in the sand. At some point, we're going to have to switch over to just licensed entities serving the people. And at what point do we say, well, we have enough provisioning centers to support the people of Michigan? And this might seem tough and it might seem unfair, but this is the deadline that the state has set. And so this is the line in the sand, and they drew it and we're abiding by it. And it's going to be difficult. There's going to be a rough patch here while the state is getting their industry up and running. And, if you can only obtain product from other licensed entities or have to test things from caregivers within a certain amount of time, it can be very difficult. But this is something that the state's just going to have to work through right now unless we get other guidance from Lara. I know that there's been a lot of talk about what if I was a temporary operator and my application is currently pending, but I had to shut down and I have all this product on my shelves and I'm up before the board next month or 2 months from now. Can I just keep that product and then have it tested once I'm licensed? I know that this has been like a topic that's been going around. Can I hold on to it? Can I sell it? Do I have to destroy it? And there really hasn't been any clear-cut definitive guidance from the state on this point. Nick, can you expand a little bit on that?
Yeah, so I think Jennifer's right in saying that there's no guidance for that, meaning that there's really not a good, confident way to say you can do something or can't do something. So we can only really base our advice on the law and the rules that are out there pertaining to these licensed facilities now. Because what happened too was what happened between October and November was that the state issued its permanent administrative rules. And one thing that I think gave me a heads up for the fact that temporary operation was coming to a close was the absence of any kind of temporary operation rules compared to the emergency rules. So there being no guidelines once those permanent rules became effective somewhat meant that besides the court order that expired, there was really no way for a temporary operator to be operating within a rule framework. So there was that. There was also a licensing board resolution that had to do with patient access, but that only involved actual licensed facilities. So again, so we're talking about only licensed facilities. They could take in caregiver product without it being held against them until December 31st. As of now, they can only take in product from licensed facilities. The stuff that they did get from caregivers, they have to have tested by the end of the month. And then it's really no guidance as far as provisioning centers as to what they can do with that after. For licensed growers and processors, they can continue through this resolution and have it not be held against them to bring in product for the growers and processors, source that from caregivers through the end of February 28th. But that's just for licensed facilities. So this resolution had nothing to do with temporary operating facilities operating under local approval. The only thing that was kind of keeping things running for them was this court order that ended up expiring. And so with that said, nothing in the rules, it kind of defaults to the law, which says that you need to be a licensed facility and have your fully approved state operating license in order to possess a certain quantity of marijuana, to grow or process a certain quantity, to sell it to secure transporters or have it tested. So, and this might not be the most popular answer, but if you have been a temporary operator and you did have inventory, there was certainly some heads up that maybe it was kind of, time was running out and you shouldn't restock your inventory, but without there being any guidelines for how to test it or if you're allowed to keep it, and then let's say you get approved during the next board meeting, should I have kept that, should I have not have? I think the best, safest advice is that all should have been destroyed. Otherwise, there's really no mechanism or safety net or rule or guideline you could point to say, oh, I was allowed to have this. And I think that's the safest way to go about your operations, especially if you're considering getting a license in the near future.
And I know that as lawyers, often we are the champion of unpopular opinions, but destroying the product is probably the best way to preserve the goodwill on the board if you're pending the approval or denial. Saying, listen, there's no guidance, we don't know what to do, we destroyed it because we knew that we didn't have authority to keep it and have it tested. That will show the board that you're willing to do what it takes to comply with LARA's rules and regulations, and that's really the best route that we can think of right now. So if you're pending appeal or if you're pending just your first review, then I would consider destroying the product, absolutely.
And I think the mantra has always been for temporary operators is that LARA wanted to see a good faith effort to get into compliance with the law and the rules. And so with the temporary operation rules and the emergency rules, you had to keep going along in the application process through phase 1, phase 2, phase 3, step 2, pre-licensure inspections, the whole shebang. When that temporary operation rule expired, I don't think that there's any better way to show a good faith effort to comply with a non-existent rule than to make sure you comply by not breaking it and by complying with what's there as the law and needing to be an actual up and running licensed facility. With that said, though, I do understand that now with temporary operators closed, there is a shortage. There was a shortage before because of the licensed growers and licensed processors being so few, far between, and the testing facilities and secure transporters potentially not running at full capacity. So now you have an even shorter supply of medicine that is going to be expected to be tested and dispensed from even fewer amounts of licensed provisioning centers. I know a few patients who had mentioned even before this that there were fewer product lines available, higher prices, And I think now, this is kind of, a turning point where we really need to be more efficient, and the whole system, that starts with the applicants providing a complete as possible of an application to LARA, which allows them then to vet you and process your application faster, which then gets you before the board quicker, which then gets you up and running and licensed. And I think there's some kinks and some wrinkles that needed to be ironed out in the system, but I think now more than ever, we need to be efficient and make sure that all of these licenses get approved and things continue going forward. Because as you've seen in other states, things like this shake up the system. Even in California, I think on the 9th, they're going to close down all the unlicensed operators there. So even other states are dealing with this problem. So it's nothing new to the industry overall, but certainly, more locally, it's affecting a lot of people, especially the patients who need this medicine, who have been relying on these storefronts that were in existence for 10 or so years until now. All of a sudden getting, closed down certainly creates a problem within the system.
Absolutely. So the state marijuana licensing board, MLB now, they are back to their normal schedule of just one meeting a month. I am hopeful, we are hopeful, that they will start taking more applications under review at each of these meetings, because we do need to get this industry up and running to counteract this shortage that we're experiencing. So, of course, we'll be keeping you updated with any developments on the licensing board meetings and updates from the state as they come down. But for now, we have the death of temporary operators. May they rest in peace. If you have any questions, please feel free to comment. We'll be posting once we see your questions. And make sure to like our Facebook page and follow us on Instagram. Thank you so much. See you next week.